Welcome, everyone. I'm so glad that you could join today for our talk on powers of attorney, mental capacity, and substitute decision making. I want to share with you that this is part of a fellowship from the Law Foundation of Ontario. And I want to start by acknowledging our generous funder, the Law Foundation of Ontario, in helping our powers of attorney project really get the steam that it needs to. And the reason why I want to start off by acknowledging our funder is because we have so little information available that helps to train people in being an attorney and to understand what are the responsibilities. As we open up our webinar today, I do want to say we are recording and I do have slides that I will show as part of it. We have some of our team members from CanAge active in our chat, and we would love to hear from you. So for those of you who are at your computer or at your tablet, do feel free to have a look at, for in terms of housekeeping, the bottom user screen. You'll see participants, chat, share screen, and so on. We encourage you to be active in the chat. Also, if you have any questions, you can put them into the Q&A bubble. We'll make sure that we get the questions to you as quickly as we can today. I will be monitoring the chat as we continue on. So if you've got live questions, feel free to put them into the chat or into the Q&A. We're going to start off with a little bit of teaching first and then get into our more dynamic section a little bit later. So I just want to share, first of all, that I'm so pleased that you were able to join us today to talk about the really important issues associated with powers of attorney and with advanced care planning. And so today, I just want to take a second or two to introduce you to our organization, which is called CanAge, Canada's National Seniors Advocacy Organization. And we are a nonpartisan organization that works across the country. We have offices in the Faculty of Social Work at the University of Toronto, and we have a particular interest in making sure that people have the tools that they need in order to make the positive change that we know are critically important always. But the issues like substitute decision making and consent capacity have a special concern when we're thinking about in the context of COVID-19. I just want to take a moment as well to orient you to our foundational document, which is called the Voices of Canada's Seniors. And we talk about this document as having a number of compass points. We look at violence and abuse prevention, optimal health and wellness, infection prevention and disaster response, caregiving, long-term care, home care and housing resources, economic security, and social inclusion. And so when we're thinking about substitute decision making, we are thinking in many of those different aspects. We're talking about issues associated with elder abuse and elder abuse prevention. We're thinking about how this relates to decisions about finances and decisions about long-term care. Our organization is committed to advancing the rights and well-being of Canadians as we age, and we're very focused on turning our work into positive impact. What we're going to talk today about is what is mental capacity, what is consent, and how does this have to do with powers of attorney and substitute decision making. So the information is going to be very practical, and again, slides will be made available to you on our recorded session. I'm excited to see that we already have some connections and questions in our chat and in our Q&A, so do feel free to be active in that. We'll talk a little bit as well about how we manage to deal with the powers of attorney documents, because not everybody is both comfortable with it, and sometimes there can be challenges in recognizing that. But in the end, what we're talking about mostly is we need to understand what mental capacity is. So mental capacity in law is the ability to understand and appreciate. So you can understand information, weigh it up, appreciate the consequences of that, and then make a decision. Let me give you a little bit of a sense about how to open that up and understand it a bit more. My grandmother at 94 was a lifelong diabetic, and she would sometimes get shots for her insulin to support it. In her significant dementia, she would see the nurse coming and see that there was an injection, a shot that was coming her way, and she would do this. She would withdraw or shrink away. She appreciated that the nurse was going to inject her with something or cause her pain. The shot was going to hurt. But she couldn't understand that it had to do with her insulin and her diabetes. So she would not have had the ability to make that decision about her healthcare consent. She didn't both understand and appreciate. Can you understand but not appreciate? Absolutely. I had a fellow I knew years ago, and you could ask him chapter and verse about schizophrenia. He would tell you everything there is to know about schizophrenia. You could quote medical information, social information, give you the checklist of all of the red flags. If you asked him about his schizophrenia, he'd say, I'm not schizophrenic. Indeed, been schizophrenic for at that point about 30 years and regularly institutionalized. He understood schizophrenia, but not his appreciation for the fact that he was schizophrenic. So you need to be able to understand the information and appreciate the consequences. The other piece of it, and this is a little bit of a harder one to grasp, you have to be able to understand and appreciate. It doesn't mean you actually have to do a thing or make a wise decision. So wisdom or good decision making is not part of it. Imagine this. I have teenagers. My teenagers dump their hockey equipment, their ballet equipment, their school bags, their winter boots, all in the front hall. I tell them, look, you can't do that, or if someone's going to open the door, flip over the stuff, and I'm going to get mad. Do they understand that they're not supposed to leave all of their items in the front hall? Absolutely. Do they appreciate that it could cause harm, that someone could flip over it, and that I would get mad? Absolutely. They have the ability to understand and appreciate. It doesn't mean that they actually do clean up their things or change their behavior. So again, we're asking whether or not the person has the capability to understand and appreciate, not to make good decisions or to change their behavior. It's also really important to know that anyone can lose capacity at any time. You can have had medication that makes you wonky. You can have an accident that would knock you unconscious. You can have one too many cocktails one evening. Any of these things can make it so that you have a fluctuating capacity. So we think about capacity as a continuum. Hopefully, all of you right now are in some form of capability. You're able to understand the information I'm giving you and appreciate the consequences of having it. We slide capacity. So imagine, for instance, you've had surgery. You've woken up, but you're on heavy medication. Are you completely incapable? No, you're not unconscious. But are you capable of making all of your kinds of decisions? Probably not the time to do your significant investment accounts at that point because you're wonky and you're woozy. I know there's not medical terms, but everyone understands what I'm talking to about that. So people can have fluctuating capacity. This is especially true if you have some form of cognitive impairment like a dementia. Many of you will know somebody with dementia who may be better in the morning and then more agitated and more confused later at night. You may have somebody who is an alcoholic that you know, and if you get them before 2 in the afternoon, they may be just fine. But if you get them after cocktail hour, it may not be that they can fully understand and appreciate. It's really important to know that capacity is always presumed. So you have to have it proven otherwise. And this can be a really hard point for people who are trying to act as attorneys. And we'll talk more about that later. But capacity is always presumed. So capacity can fluctuate. Anyone can be more or less capable under any circumstances. And dementia is not the only type of capacity. When we're talking about decision making, we're really talking about who is going to decide and who needs that decision. So we talk about having powers of attorney, which are, by the way, the documents, not a person. We have powers of attorney in Ontario, and this is Ontario-specific information. You would need 2 of them. One is a power of attorney for personal care, and the second document, and is a second piece of paper, is the power of attorney for property. The power of attorney for personal care document talks about how a decision would be made for your healthcare, which is usually what we think about, but also how you live in the world. So they may determine where you live in an apartment or a long-term care facility. They may determine what type of supports and care that you would need or food. It's really not just medical care, it's also personal care. The other document is the power of attorney for property document, and it appoints a person to make decisions about your property. And those of us that often use the word property, we may think about it in terms of real estate, but that's not only what we're talking about here. We're talking also about your money, your bank accounts, but also your couch and your necklace, your car, your investments. It's any of the stuff in your life. Important to know, in some jurisdictions, you may have one document that does these two things together, but not in Ontario and not in most other jurisdictions in Canada. In the US, sometimes they have them as one document. So when you're thinking about your advanced care planning and powers of attorney, you're looking at creating two documents. Doesn't mean it can't be the same person appointed, but it's two separate documents. Let's look at that a little bit more specifically. If you're a capable adult, you get to decide. And I use the word adult, and that's really important here because not everybody gets to make decisions. If you're a 3-year-old, you don't get to make legal decisions. You have to be an adult by the definition of the legislation. And the legislation in this case is the Substitute Decisions Act. It's different legislation in different parts of the country. So again, I'm only talking about Ontario. So it's really 16 and 18. 16 for personal care to be an adult and 18 for property. If you're a capable adult, you get to decide. If you're an incapable adult, so imagine you're crossing the street, you get hit by a bus, you get knocked unconscious. Somebody else is going to have to make a decision for you. They scrape you off the ground, they take you to hospital, you are unconscious. Someone's going to have to make a decision about whether you're going to have surgery, whether or not you've got future care planning needs. That's the health and personal care. But someone's probably also going to have to pay your bills for you because you are unconscious in hospital. You got to pay your rent. You got to pay your bills. You got to pay your mortgage. And that person is your power of attorney for property. So again, let's be clear. The document itself is called the power of attorney. The individual that we appoint is called the attorney. It doesn't mean lawyer. It's a confusing term, I know. So if you are an attorney, it's because you've been appointed to be the decision maker for somebody else, either for personal care or for property. You may be appointed for both. We're going to talk about 4 kinds of powers of attorney, but really number 2 and the 3 are the ones that you need to know about most. But I just want to let you know that there is something called a general power of attorney. We really don't use these anymore. It's a walking around document and has really been replaced by debit cards, Interact, and other ways like Apple Pay. But it used to be, before it became so easy to move money around, that if I wanted to go grocery shopping for my grandmother, I would have to take her checkbook with me. Can you believe that? And I would do her grocery shopping and I would write a check on her account and I would give it to the cashier because I was acting as her. A general power of attorney, which is extremely rare now, ends at the point of her incapacity. It's really a walking around document. We just don't see them much anymore. This is not a planning document. This is one that you really should pay a lot of attention to. When we're talking about powers of attorney, this is mostly what people are talking about. We call it in Ontario a continuing power of attorney. Other jurisdictions may call it an enduring power of attorney. Americans sometimes call it a durable power of attorney. In Ontario, we call it a continuing power of attorney. It all means the same thing. It means the document is active right away and then continues past the point of incapability. So let me break that down for you. So if my grandmother wanted me to do her grocery shopping, I could do that right now. I could spend her money. She could, while she is still capable, watch over the decisions that I make. If she doesn't like the decisions I make, she can decide to correct that or change me and stop me being a power of attorney as the attorney. So when she's capable, she's in the green box, and she can look down and say, yes, you can help and make decisions, but if I don't like your decisions, I still get to make those decisions, or I can fire you as my attorney. Let's say my grandmother goes into a diabetic coma. Then she's incapable of making decisions. I don't have to do anything or trigger anything to make decisions for her. I've already got the power to make decisions. It's a continuing power of attorney. There doesn't need to be a specific thing to be done. Some people are concerned about this because they certainly wouldn't want anyone messing in their affairs, particularly property affairs, where they're mentally capable of doing so. Well, you don't have to have people meddling in your affairs. In fact, most people don't. But this can be very helpful if you're going some way away and you need someone to look after your house, for instance, or you want somebody to be able to renew your car insurance for you. So it's about the conversation between the person who's the donor, the one giving the power of attorney, and the attorney, the person who's receiving it. So you can say, I'm appointing you to be my attorney, pursuant my power of attorney for property, but I don't want you to do anything right now. I only want you to do it after I become incapable. That's fine. So there's risks and benefits to both. Well, what if you don't want somebody to have the ability to make decisions for you until something happens, like you become incapable? Well, this is very much like getting a credit card that has a sticker on it where you have to call a 1-800 number to make it spring into effect. Michael asks in the chat, I thought the power of attorney is triggered only once a person was deemed incapable. That's exactly what we're talking about now, Michael. Thanks very much for your question. A springing power of attorney is triggered by something. So it's created, but it's asleep. It's dormant, like that credit card that has the 1-800 number. It's active. But then something will happen to trigger it, and it then leaps into effect. So that's different from the continuing power of attorney that we talked about before, where it's active upon its creation and then continues to be active after a person becomes incapable. The other choice is it's asleep, it's dormant, and then something happens, it's triggered, and then you take over. That's called a springing power of attorney. So in the document itself that you would receive, you need to read which type it is. Is it the type that is active right away and then continues on after a person is incapable? Or is it a springing power of attorney, which means it is not active right away, but only becomes active? You can only use it after something happens. Here's the challenge. Many of you may have had the experience of trying to actually get somebody's capacity challenged. It's not easy. Ontario has something called the Capacity Assessment Office. So you can actually purchase at a private pay basis a capacity assessment. And the challenge there is that the person whose capacity is at risk, let's call them Bob. Bob is showing signs of cognitive impairment. You have been appointed as attorney for Bob. Bob's starting to actually act in ways that you're quite worried about. You're thinking to yourself, is it time that maybe I started acting as an attorney? Do we need to spring this document into effect? What do I need to do? What does Bob need to do? Bob needs to get a capacity assessment. And so it may be that you don't actually have the ability to get Bob to take a capacity assessment. And then you'd end up in court to get a court-ordered one. So it can be very difficult. In some cases, Bob might be, sure, yeah, I'm happy to take a capacity assessment. Sure, I'm happy to pay between $500 and say something like $1,500 for a capacity assessment to show whether or not I'm mentally capable of making certain decisions or not. But often it's not such an easy thing to do. When you're assessing capacity, and Sophie's asking here, that when you've got a question of fluctuating capacity, how do you know that the capacity assessment will respect or indicate that fluctuating capacity? Great question, Sophie. Thank you. So capacity assessors are trained to be able to identify fluctuating capacity. They may come several different times, not only one time. They may be on the lookout for certain type of triggering questions that would be confusing, and they're trained to dig more deeply. But remember, the person has to agree to be assessed. And many people would not agree. It's a very invasive process to have your mental capacity assessed. So the person has to assent, ASSENT, which essentially means they don't disagree. They don't have to consent to a capacity assessment because, of course, that's the very question at hand. Do you consent or not? Do you have mental capacity or not? If the person who is undergoing the capacity assessment at any point wants to stop it, it gets stopped, and it's an incomplete capacity assessment. So why am I spending so much time talking about this? It's because when we're talking about powers of attorney, we have to decide, are you going to create one that's active right away? It has a bit of risk in the sense that somebody could try to meddle with your affairs while you're capable if you maybe didn't know that they were trying to do it. But it continues on past the point of incapability. Or do you need to get a capacity assessment to make it spring into effect? That's a decision people need to make. There is another kind of power of attorney document that's out there, and it's not helpful for capacity planning, but I just wanted to let you know what it is. It's called a limited power of attorney. For sure you have done this. Maybe you needed someone to renew your car insurance and you turned over the form and you signed somebody's name and they did it for you. That's called a limited power of attorney. Maybe you needed someone to pick up your passport for you. So you actually signed a form, a limited power of attorney that let them do that one thing. Not helpful. As you can see, it doesn't go into the point of incapability. And when we're talking about advanced planning, but there are these different types of powers of attorney. It can be helpful if you do need your passport picked up. It's really important to know that we're talking about Ontario. Every jurisdiction has slightly different rules when it comes to powers of attorney. I strongly recommend, and I'm giving you legal information and not legal advice, I strongly recommend that if you have property in other jurisdictions or you have a power of attorney document from another jurisdiction, that you get legal advice and if you should be creating new ones in Ontario. Well, what happens first if you don't have a power of attorney for personal care? And let's be clear, about 2/3 of Ontarians do not have powers of attorney, okay? 2/3. So when you're thinking about your professional practice, you can imagine that, assuming that a person has a power of attorney is not going to get you very far. So here is what it looked like. Always, again, capacity is presumed. If you're a capable person, then you get to decide. You get to tell your doctor. You get to tell your financial advisor. You get to tell your banker. You get to tell your landlord. You're a capable person and it is presumed and you get to decide. And remember, you can be capable of some things and not others. So imagine, for instance, you may have a dear friend with Down syndrome, and that friend may be able to make good, solid, everyday banking decisions, but they may have some challenges and need some extra help and support with advanced financial investment decisions. Anyone may need some extra help with financial investment decisions. So they may be capable of making some decisions like routine banking, but not others. That may be the same for a person who may have cognitive impairment. They may be able to make some decisions about their healthcare, but not others. So it's always decisional and capacity is always presumed. But let's talk about what happens and what's the ranking list. For those of you who may play a game that has a trump card like bridge or euchre, you may know that in the end, a guardian, a person appointed by the court, is always the top ranking. But they're very, very rare and very expensive to go get. So they are an unlikely answer. When we have problems about trying to get decisions for people, often folks end up in court if they can afford to do so, but many, many people can't. So again, I put it in a bracket because there are very few guardianships, and the idea of going to court may be clear in theory, but may be very difficult in practice. You can make a power of attorney for personal care. You do not need a lawyer. There's a guide and the forms from the Ministry of Attorney General's website, and we'll put the link in the chat for you, and we'll also send that link around after. And if you follow that guide and follow the way that it gets signed, which is 2 people who are adults who are not named in the document and not excluded in the list, you can see it in the guide exactly who can't sign, 2 people in the presence of each other and the person making it, and you can execute a document without a lawyer. I always recommend, wherever possible, try to get some legal advice and try to get a lawyer to do it. But do you require that? No. You can see sometimes those personal power of attorney kits in drugstores and grocery stores. I really don't recommend them. They are often created in other jurisdictions and are not legally correct in Ontario. I would say if you're going to actually use a power of attorney kit and not use a lawyer, then use the one from the Ministry of Attorney General's website because you know it's legally correct and it has an excellent guide. Okay, so we've learned about guardians. They're very rare and it would be court appointed. You'd have to go to court and ask to be a decision maker. It's going to cost you tens and tens and tens of thousands of dollars. You can make a power of attorney for personal care. You can make it for free if you follow the kit, or you can go to a lawyer. And then if you don't, if you're part of the 2/3 of people, you've been hit by a bus, somebody is unconscious, you're taken to the hospital, and ongoing decisions need to be made. This is the default list. It'll go to your spouse or partner. If you don't have one of those or they're not available, then it will go to all of your adult children equally for a decision. If you don't have adult children or they can't agree, it will go to your parents. And that doesn't work, it will go to your siblings. Again, everyone has to agree together. So if you have 5 siblings, it's not the eldest, no matter what they say, it's all 5 of them together. And then it goes to any other relative. And you can certainly see how difficult that actually is. So if you pick somebody to be your power of attorney, your attorney pursuant to that document, then you have control. And it doesn't have to go every single time. This is important to remember that if you're picking someone to be your attorney, it's an ongoing job, where this default list is for individual decisions. So it's not a good idea to just leave it to chance. You are a spouse if these things are true. You're married to them, or you've been common law for a year, you've got a cohabitation agreement, or you have a child. If this is a partner, if they've lived together for at least a year and you've got a close personal relationship. So it's really important to know that that's what it means in this Substitute Decisions Act. Okay, we talked about personal care, card-appointed guardian, then, which is rare and expensive and difficult to get. Power of attorney for personal care, which is free if you do it. So you can use the, and I prefer if you get legal advice and get a lawyer to do it. And then you've got this default substitute decision-making list, which gets done decision by decision by decision. Complicated, difficult in many cases to navigate, and many people would not agree. So you end up in a tussle. But what about property? It's even kind of more complicated. Again, if you're a capable person, you get to decide. If you're hit by that bus, which is the vertical line, and you're incapable, it's the same thing, court-appointed guardianship, a little bit less uncommon, but still, same challenge, got to go to court, costs tens of thousands of dollars, difficult. Or you've appointed a person to be an attorney pursuant to a power of attorney for property. Again, same thing. It's in the kit, downloadable. I prefer you get legal advice, but you don't have to. There is no default list. So if you do not have a power of attorney for property, your file will go to the public guardian and trustee. And that means that they're going to have to try to figure out what to do with it and try to find somebody to be a decision maker for you. Who to appoint as an attorney? Find somebody with good social skills. Find somebody who doesn't mind bookkeeping, because if you're a power of attorney for property, you can't just throw it all in one account and call it a day. You have to actually do what we call trust accounting, which means you need to keep a scrupulous account of the money that you are spending while you're standing in somebody else's shoes. Because it's not your money, it's their money. You also need to pick somebody who will do and act in a manner that you would want them to, and who is willing to make decisions that you would want. So let's make it a bit more clear. If you are a person that would want all kinds of life-saving techniques, including blood transfusions, it may be difficult for you to pick somebody who may have a religious belief against blood transfusions. They would have to make the decision that you would want, which is to say, yes, Laura wants a blood transfusion, but that may be very challenging to them as a person. So you may want to ask them if they would feel comfortable making a decision that goes against their values and beliefs. The attorney must always make the decision that person would want them to make, up until it is actually really against their best interest and impossible. So for instance, imagine if I had $1 million. And so I had been gifting money regularly to a number of charities. I get hit by a bus, I'm unconscious, and my property decision maker, my power of attorney for property attorney, says, well, Laura always wanted to gift this money, but there's been a massive stock market crash since she's become incapable. And so now she goes from $1 million to $100,000. And yet the gifts that she gives every year are more than that. So that would be an example where you couldn't actually follow the previously expressed wishes. But otherwise, that's what you have to do. I also recommend that you appoint somebody who has a backup. So imagine if you appoint your partner. So I want to choose my husband to be my attorney as my first choice. That's really common, your spouse partner. I'm not saying it should be, but it's common. But we're in the same car accident. So who will I have as a backup? You can have 1 or 2 backups. I have 2 because I'm a cautious person. And I think it's always helpful to have an alternate person, a backup person who might not be in that car with you. So think about that friend or relationship who is detail-oriented, honest, somebody who's able to navigate tricky situations, understand and respect your wishes, who's ethical, who's good with details and record keeping, but maybe isn't on vacation with you all the time. One of the questions we're often asked is, how do you revoke a power of attorney? So if you are still capable of making a power of attorney, you are still mentally capable of revoking a power of attorney. And here on the slides, you can see the details. And again, the slides are going to be made available to you, so you don't need to go writing this down. So you can revoke the power of attorney as long as you have the ability to make an attorney decision. The other thing I just want to talk about before we go into our Q&A session is, can you pick more than one person to be your attorney? Answer, yes. So we talk about joint attorneys and several attorneys. So let me give you an example. Let's say my mom and dad have made their advanced care plans and their advanced property plans. My dad says, all right, I've chosen my wife to be my first person to make my decisions. I've appointed her as my power of attorney for property under one document. I've also appointed her as my power of attorney for personal care under a second document. Fine. I'm going to ask you and your brother to be the backups. If we're in the same accident, she can't do it, or she's away traveling, or some other reason. Then my dad has to decide. When he's going to appoint my brother and I, do my brother and I have to agree on the decision jointly? Or is one person or the other, first to the bank and first to the bed, good enough? Is either of us individually able to make that decision? Severally. I have been asked before, can I appoint all 6 of my children to be my attorneys? Yes. Should you? Absolutely, you should not. When you're thinking through who to be your attorney, first of all, ask them if they're willing to do it. That really makes a difference. And remember also that they may be doing it for 20, 30 years at a time. If you have an illness that is chronic that stops you from being able to make decisions independently, it could be a long-standing issue. So ask if they can do it. Try to find somebody who lives quite close by to you, particularly for personal care. For property, it's a little bit less of a concern now that we have such online banking and online finance. But again, try to make sure they're in hopefully the same province you are, if not, at least the same country. And I'm just going to close by saying powers of attorney can be used well or misused. If you maybe in an instance where people are using powers of attorney documents to do things that they should not do, whether they're stealing money from somebody, or they're trying to submit the will of the person, or they forced somebody to sign one. You're not allowed to do that. There's civil liability, which means you can get trouble and get sued. And there can be criminal liability. Under Section 331 of the Criminal Code, misuse of a power of attorney is a criminal offense. When you're making a power of attorney document, you have to decide, are you going to let that document cover any decision that's property deceased and any decision that's personal care, or do you want to put some restrictions in it? And there's a point in that document where you get to make a decision. So you may say that you want your uncle to be your property decision maker, but only have certain decision restrictions. So that's another thing that we need to think about. The last thing I want to close on is the misunderstandings that people have when we're appointing them. So the attorney, the person who gets the authority, sometimes people think, well, I can spend that money. It's, they're not going to miss it. It's really not their money. It's my money. She appointed me the attorney, or I'm going to inherit it anyway, or she's so out of it, she's never going to miss it. And that's not appropriate. You must do what the other person who appointed you would want you to do, and you must act with the utmost good faith at the highest responsibility. That's called a fiduciary duty. The person who gives the document, a donor, and I like the name donor because it feels like you're extracting an organ, and it is that big a deal, often thinks that somebody would know what you would want. Assuredly, they don't. Try to get them to write it down or tell you. There's a misunderstanding about something we call living wills. There's no such thing as living wills in Ontario. If you write down your wishes, it is just an expression of what you thought at that time. It doesn't have any special meaning. So you can express your wishes to your attorney verbally, in writing, or by any other way. And your most recent wishes are the ones that they must pay attention to. So if they change their mind a number of times, it's the most recent version. Sometimes there's also a myth that you can actually make a medical assistance in dying decision for somebody else. That is not true. You cannot. So a substitute decision maker of any kind, including a power of attorney decision maker, cannot make a medical assistance in dying decision. So again, you get to slip into somebody else's shoes and make a decision what they would do. There is movement, and it doesn't yet exist in Ontario, for something called supported decision making. And this is this idea where we don't take people away from their rights, but we keep people and trying to help them. So in the example of the person with Down syndrome, instead of taking away their rights to make decisions, we would just try to provide them information and support. And so it doesn't yet exist in Ontario, but we're looking at it. I know we've got lots in the chat, and I'm going to pull into some of our team members in just a second to ask questions and summarize some of the questions in our chat and Q&A, and I'll answer them live with you now. But in this also, there's a number of resources that you have before you that will help you in understanding more how to make good decisions as an attorney, what it is that you're supposed to be doing, and what your rights are. So at this point, I'm going to invite Xanthi to help us. Thank you, Xanthi. So Xanthi is a student at the Factor-Inwentash Faculty of Social Work. And I'm going to ask you to let us know, what questions do we have going in our chat and our Q&A today, Xanthi?
Hello, Laura. Thank you. Yes, we have many amazing questions here. So our first question from Andrea is, what happens when the home won't recognize the substitute decision maker?
Yeah, it's a really big, important question. And I'm going to extend that as well, not to just a long-term care home, but just to anyone who doesn't recognize it. So whether that be a bank, a financial institution, like an investment advisor, or whether it be a doctor, it doesn't really matter. What happens if they won't recognize them? So two things. One, it may take them a little while to actually recognize it. They may have their internal protocols, and that's appropriate. It's particularly for financial protocols. They may need to check in with the person who is in fact their client or their patient, depending on the context. If that person isn't completely unconscious, they will ask them, hey, did you make a power of attorney document? And is this person your attorney? That's good. We want them to check in for that. A financial institution may also escalate it up to their legal department for review and have their internal review protocols. You should expect that as well. So it may take a couple of days to go through. If they were continue to refuse the document, that's where we get into a challenge. And we need to understand more on what basis they're refusing the document. So that's where we're going to have to get into it. And we can talk more another time about how to do it. But actually, mostly we get into problem solving. In some rare circumstances, you may need to hire a lawyer and get them to actually recognize it, but it can be a real challenge. The last piece I just want to share around that is, a piece of information I would warn you about. Sometimes financial institutions ask you to sign their own banking power of attorney that they have. It just oversees their own. Any financial institution or bank may say, oh, I don't know about your professionally drawn power of attorney there. I want you to use mine. It's my strong suggestion that you think very critically about that, because they're drawn to their own benefits. And if you fill out a new power of attorney, then that revokes your old one that you may have drawn to the degree that they conflict. So really, I don't recommend a banking power of attorney. But thanks for the question. It can be sometimes a bit of effort to get people to recognize them. What do we have next, Anthony?
So we have another question from Celia. What happens in the case of someone born with a disability, such as a moderate or severe intellectual disability, who has never or will never be able to sign a power of attorney?
Thank you very much. So in those cases, we end up typically having to get a guardianship. That's usually what happens. So if you had a person, and I hate this term, so I apologize for using it, but we talk about people who are never capable. Now, I don't believe that anybody is never capable, but that's an old expression, and we still sometimes use that old never capable. At that point, you are going to probably be moving into a guardianship. Now, under a more modern regime, which we don't yet have in Ontario, we would hope to be able to use supported decision-making, but we're not there yet. Oh, since I asked, does it actually say springing power of attorney on the document? Rarely, no. You have to read the document itself. There will be a segment in the document that says, when is it active? Occasionally it will say, it will say continuing power of attorney or power of attorney at the top of the document. Depends how it's drafted. You must read the document to see if it's one that starts right away, or is there a section about activation that says that it's got to be triggered by something.
Thanks, Laura. Okay, we have another question from Daniela. Does the person always need to be assessed for capacity?
Absolutely not, Daniela. So first of all, with a continuing power of attorney, there's no need for an assessment because it's active right away. So as an example, my husband and I have continuing powers of attorney for each other, and I got him to renew my parking sticker at the City of Toronto because I didn't want to wait in line for 3 hours, and he was going for his car anyway. So I sent him with my power of attorney document for property because it's a car, right? And I said, while you're at it, slip on my mental shoes and give them my document and see if you can renew it right away. So it had nothing to do with capacity, and it had everything in that way to do with convenience. If we're talking about a triggered kind of power of attorney, a springing power of attorney, it could be sprung by a number of different things. I had a friend of mine who was going to an area which was a war zone where there was a lot of kidnapping and ransom, and it was triggered for her if she got kidnapped or there was a ransom. Now that's unusual. Mostly it is triggered by some type of assessment of capacity. You can, however, decide what would trigger it. So some people will say, if my best friend Beth decides, or my partner and 2 of my children decide that I'm mentally incapable of making the decision, and they don't actually require a formal medical capacity assessment. But that's unusual too. you have the ability to. In these cases, I would really recommend talking to a lawyer. Again, I'm giving you legal information and not advice. What else do we have?
All right, we have another question from Sophie, who is asking what happens when someone comes to assess a person's capacity and they come on a day when the person's dementia is not as prevalent as other days. If they deem that person has capacity to understand and appreciate, and the family is concerned that most days the person does not have capacity, what happens next?
Yeah, so fluctuating capacity is a real challenge. There's no question about it. And certainly when we have fluctuating capacity, it's not necessarily just dementia. It could be because of a delirium. It could be because of a depression. It could be because of mental health issues. So understanding we're not only ever talking just about dementia, it could be a number of different issues that fluctuating capacity. Capacity assessments are usually a moment in time. So if it comes to it, we may need to be able to say, look, there may need to be a number of different touch points. It is, however, our job not to make people incapable. It's our job to support capacity. And so it may be that we're trying to actually get people help. The gray zone where you think the person is sometimes capable and sometimes not, there's no magic solution to that. It can be a real challenge, which is one of the reasons why I teach in the Faculty of Social Work. These are often social work problems and not actually law problems. We need to have some full and frank conversations with people about what we need to do in order to make good decisions and what they would want us to do. So whether or not they're willing to accept help or try to understand if there's ways that we can manage around it. So let's just think about property decisions. It may be that you can set up automatic bill paying accounts and not have to worry about trying to spring a power of attorney. Try to think about what the end goal is that you're trying to achieve and work backwards to see if you have to use the power of attorney document or are there other ways. But it's hard, and I don't have a magic wand for that one.
Thanks, Laura. So we have another question from Andrea, which is, who do you report to if you suspect an attorney is abusing their rights as a POA?
Andrea, this is a really, really important question. And we know that power of attorney abuse is a real and substantive thing. And in some cases, we think it's really on the rise right now, particularly in the time of COVID-19. So there's not one great, I'm going to give you the structural answer, but then I'm going to let you know that it's not so easy. Okay. If there is a combination of that the person may be mentally incapable, so the person themselves may not be able to understand and appreciate, and there's a significant concern about loss of assets, then the Ontario Public Guardian and Trustee can be called. You will need to be very clear to them that the person is incapable, or you have a substantial reason to believe that they're incapable and that there's a substantial risk to assets. Otherwise, they may not find that it's their jurisdiction. Our public guardian trustee legislation is old and out of date and is not as good or modern as, for instance, the ones in BC, Nova Scotia, or the Yukon. So it is not as responsive to elder abuse and neglect. You can always call the police. There is, for all of the GTA in Ontario, one police officer whose name at this point is Mark McCabe, who will help and support. In some other jurisdictions in Ontario, there may be elder abuse leads. Try to find somebody with that designation. Many times we're often led to understand that, police think this is a civil matter. Many, many people are really trying to problem solve. So, my first instinct is talk to the person, so there's a systems answer, which I've just given you, but there's a really important answer is talk to the individual if they are, in some cases, capable, not unconscious, and find out what they know and what they want and try to help. It may be that they know abuse is going on, they're perfectly mentally capable, and they've made a terrible and very difficult decision to live with some form of abuse because they may only have one person in their life, their son or daughter or grandchild, and they know that we are in a difficult situation and they're working with harm reduction. And so we need to understand before we can step in and trounce somebody's individual rights to live at risk, we need to know if they're mentally capable of doing so. If they are in a very dangerous situation, they'll call the police. This is not a perfect answer for you because our system is not a perfect system.
Thanks, Laura. I have another question here from Allison, who's asking if the POA is signed in Ontario, be applicable in other provinces or other countries?
Yeah, difficult on this one. My strong recommendation is if you move other jurisdictions, look and consult to get legal advice for that new jurisdiction. As an example, I sometimes spend time in Nova Scotia, I sometimes spend time in BC, and sometimes spend time in Ontario. I would need a good understanding about, should I have powers of attorney in each of those provinces, or can I just have one in my main province, which is Ontario, and have it indicate, that it would extend to the other jurisdictions? It gets tricky. If you're in multiple jurisdictions, I strongly suggest that you get legal advice in that answer, but it is not as crisp and easy. If you are bringing in a power of attorney document from another jurisdiction, say that you used to live in Alberta and now you live in Ontario, and you still have Alberta powers of attorney, I strongly recommend that you get those redone for Ontario if you've moved here. The laws are difficult. It may be recognized, but it will be expensive and challenging to do so. It's a lot easier to redo them if you've moved.
Thanks.
Is there a list to find private assessors for capacity? Yes, Amina, there is. You can actually just Google the capacity assessment office, or we can put it into the chat as well. And there is a list, and you can call the capacity assessment office. They will tell you by region and also by language spoken. And I know that one of the challenges we have here, Alice points about whether you do it on behalf of individuals whose first language is in English. I strongly recommend you get a real interpreter. Do not use a family member to translate for you, because remember, about 2/3 of abuse and neglect is perpetrated by those closest family members and friends. Try to get an independent person who is a registered translator if possible. If you can't do that, these days with Google Translate or translation services online, there's all kinds of other options available, but I really recommend that you don't go through a family member.
Okay.
What do we have next?
So I have another question about what happens if you don't trust the other person who is the POA for personal care, let's say, to fulfill their wishes or make decisions that protect their health.
Yeah, so I'm going to wind that also into Daniela's question about, does it have to be the same person? So first of all, we always say, if you can, make sure that you pick somebody who you trust, or pick more than one person that you trust. Make sure that they can work with each other. Not everyone has that perfect set of circumstances. That's important. So some people don't have a lot of people in their lives, and maybe they've got someone, but they're not necessarily the person who is the ideal attorney. Okay. You can actually have a backup, what we call a monitor. That means they're not a decision maker, but they have the rights to ask questions, and they have the right to also check in and see it. So you can appoint somebody to be your attorney. Maybe it's not perfect, and you can also appoint a monitor, which gives somebody the ability to dig into the decisions. You can go to the consent capacity board in some cases for personal care decisions. Okay, so if there is action and wrongdoing by a power of attorney for personal care, you can apply to the consent and capacity board on a decisional basis, and the person whose capacity is at issue may be able to qualify for what we call Section 3 counsel, so free legal representation pursuant to Section 3 of the Substitute Decisions Act. So consent capacity board, and we'll put the link in our chat right now, is a free tribunal. There's a very small fee for the filing of the papers. They have to have a hearing within 7 days, and it is an informal tribunal, so you don't need a lawyer. Some people bring lawyers, but you don't need a lawyer. And that is one of the ways to challenge a personal care decision. They do not have jurisdiction over financial, and so it's a real problem. You often end up just going to court, or you may end up hiring a lawyer and negotiating to see if that person would recuse themselves, which means that they would step away from it. Do you have to appoint only one person? No, you can appoint as many people as you want, but you need to decide, do they have to make the decision together, or can just one of those people make the decision? And if you decide that it has to be both people together, you should build in a tiebreaker. So let's say for instance, in my situation with my parents, my mom can't be the decision maker because she's in the same car accident. And so my dad makes the decision that he's going to appoint my brother and I, but we are in a deadlock. So unless there's a backup to that saying, unless, you know, Laura and her brother can't agree, then it goes to my cousin Sydney. So you can build backups into it. Generally, you're going to end up in court if you can't come to a decision, and nobody wants that. Occasionally, the public guardian trustee might step in and try to negotiate something. On the whole, good personal planning and talking to people well in advance and finding out what they think is a critically important part of this. I think we have time for one more question. Oh, I should say, Allison, a question is, if a person has property in both provinces, that means they should have a power of attorney for both. Allison, it does depend. It may not be the case. In that particular circumstance, I strongly suggest you seek legal advice. It is very individual in there as well. But if you have moved from one jurisdiction to another, then I recommend that you consider redoing in it as well. Okay. Let's just see. So Tom is asking, is someone like Laura available as a first point of contact if questions arise? Tom, you know, you can always reach out to us at info@canage.ca. We don't provide legal advice. We provide some legal information, and we've got these great resources available as well. Generally, though, we don't. In Ontario, they have the Advocacy Centre for the Elderly, acelaw.ca, and the Advocacy Centre for the Elderly is a legal aid clinic, and they have wonderful resources as well, and they are often a good point of contact for you if you've got questions about it. Particularly, remember, they only represent the older person, not family members. They will also represent the attorney of the older person if that person is incapable. Do we have any more questions we can get to now?
A quick question. If someone is now incapable, are they able to change their POA for personal care?
No. I love it when people ask me questions I can answer. If the person is now incapable, then it's too late. And that's where you end up actually having to appeal to courts typically, which nobody wants. It's expensive, it's difficult, it's dramatic. So what I hoped that you would get out of today's session, just noting our time, is I hope that you would get an overview about what is mental capacity, the ability to understand and appreciate. I wanted you to remember that capacity is always assumed. It has to be disproven. In Ontario, we do have capacity assessment offices where you can hire individual capacity assessors. That the person whose capacity needs to be assessed has to assent, not consent. So if they say no, it's done. I wanted you to know that there's two different kinds of documents that need to be created: a power of attorney for personal care and also a power of attorney for property. You can pick the same people, but it's separate documents. I really strongly recommend that you don't use banking powers of attorney, the kind that a financial institution would have, because they can really confuse the issues. You do not need a lawyer to make a power of attorney for personal care or a power of attorney for property in Canada, in Ontario. In Canada, there are different rules in different provinces. I strongly recommend where you can get legal advice, which this is not, that you should do so. A little bit of investment to hire a lawyer in this case is excellent, but if not, you can use the resources available for free at the Power of Attorney kit, and the information is in the link, and we can share that link as well. I'm going to close this session. Thank you, Xanthe, by saying that we will continue to follow up with you. We would love you to join us at CanAge, and you can sign up for a free membership. The information is in the chat at canage.ca/join. If you're interested in learning more about this, please follow into our free webinar series. You've got canage.ca/webinars, and you can see that all of our materials are recorded as well. So if you'd like to share this information with your colleagues, you can pop onto the website as well. I want to close with a particular thank you again to our funder and the Law Foundation of Ontario, and also acknowledge the great help and support as partner organization, the Faculty of Social Work at the University of Toronto. This is part of a series, and next week we're having a wonderful new opportunity as well. Please join us Tuesday, the 17th at lunch hour between 12 and 1 for a mentoring session. If you're a student, no matter what faculty you're in, or you're interested in learning more about careers and how leaders in the field of aging got to where they were, please join us. And you can find that information on our website as well. We're thrilled that you are joining us today, and we hope that you will join us next week for our next session to learn more about careers in the field of aging. There will be more information and other talks available through canage.ca/webinars. Please join us again. Thanks very much, everyone. And you'll be getting a little follow-up with some of this information and an evaluation. Take care, everyone. Have a great day.